Well, the matter arises out of a reference in the NN Global case.
Correct.
One paragraph of which is relevant. My lord, I'll read it out. My lord, but this matter has a little wider implication, because the issue which is now arising before, my lord, this honorable court and various high courts is really mainly in the section 11 jurisdiction. Because what is happening, my lord, is that there are two opposing views. One view says that if somebody points out to you that a document or an instrument is insufficiently stamped or not at all stamped, you, the section 11 judge, have no choice but to impound and proceed. That's one view, my lord. I would say that's the Garwari view. The other view which has been propounded is that no, this may not be. So, my lord, this is one possibility. One possibility which, and this is the possibility, this is what is being done now by the Bombay High Court. They are following this. But the Delhi High Court, on the other hand, is appointing arbitrators and leaving this question.
Section 16.
In section 16. Two judgments of this honorable court will not have appointed arbitrators pending this reference. There are other cases which are pending where the judges have adjourned the matter to await the reference.
Oh,
so, my lord, this is there, if I may say so, there's a khichdi, everybody is going their own way. So it is ultimately for your lordships, my lord, to lay down the law one way or the other, whichever, my lord, appeals ultimately to your lord. Now, my lord, that's the practical aspect of the matter, my lord. My lord, also, my lord, I have in this regard, we have filed 4 volumes of compilation for your lordship's kind consideration. My lord, the second volume which we have filed is in the Stamp Act, because your lordships will find that in all these judgments, the focus, my lord, because, sorry to say this, my lord, arbitration appears to be very glamorous. The focus appears only on the Arbitration Act and not much debate or not much disputation insofar as the Stamp Act is concerned. So, my lord, the Stamp Act I will place before the Arbitration Act.
Mr. Banerjee,
yes.
One question. See, an arbitration agreement is really an agreement within an agreement.
Right, my lord.
So, effectively, there are 2 agreements.
Right.
So, for the stamping purpose, what would be the valuation of the arbitration agreement? Just.
My lord, I can answer that, my lord. For the stamping purpose, my lord, it is not the agreement which is relevant, but it is the instrument. It's the instrument. Now, my lord, an instrument may have more than one agreement.
As the line of cases are there that there are actually 2 agreements so far as
yes, my lord,
arbitration is concerned.
Yes.
One is the main agreement
and one is the arbitration agreement. No difficulties.
What would be the value?
How the value is fixed, my lord, under the Stamp Act, my lord. If there is such a situation where in one particular instrument, my lord, more than one agreement is there, or more than one subject matter is there, my lord, section 5 and 6 of the Stamp Act deal with that situation, and it is really the higher value, the value of the substantive agreement, which is taken as the value of the instrument. You know, there are methods in the Stamp Act, I will show you also, which resolve it. So, my lord, Stamp Act issue is slightly different and Arbitration Act issue is slightly different. And if we keep them separate, my lord, then of course, my lord, we can match them up. Because the valuation issue, my lord, can be seen really with the Stamp Act. And unfortunately, there seems to be an error in NN Global, my lord, on the Stamp Act, which I will also, my lord, highlight. So that
will a document which is unstamped, will it be correct to describe it as unenforceable, or will it be more correct to say that it is inadmissible in evidence?
My lord, I would go with the second, and I will place those judgments, my lord. I will show that an unstamped document is a valid document. My lord, it is merely inadmissible in evidence. The underlying transaction is valid, and my lord, it is not null and void. That seems to be the problem with the judgment in Garwari. My lord, I will highlight that in the first court. So it is valid, but it cannot be, my lord, admitted in evidence. And
but you are actually saying that the invalidity and the inadmissibility, they are different.
Yes, my lord, I am deeply obliged, my lord. That is really going to be my first point. There is, and because of that, my lord, in an 11(6)(a) situation where the 11 judge only looks at existence, there is no impediment, my lord, to appoint, and there is no loss to revenue, my lord. Because one, my lord, we have to balance both. You have to balance the speed of the arbitration. You want to appoint an arbitrator quickly, you want to proceed quickly, and you want to appoint the arbitrator and leave everything with him. On the other hand, Stamp Act is a fiscal statute, and you, at some purpose, being an organ of the state, also want to protect the revenue of the state. So the question is, do you protect the revenue of the state at the stage of Section 11, or do you leave it to the arbitrator, who is also empowered, my lord, under Section 35 to do the same job? So it is not somebody who is escaping, my lord, from the tax net. Sorry, my lord.
11.6, any application,
Right.
court is to see whether there is an arbitration agreement or not.
Right.
Now, normally that agreement is annexed.
Right.
Does it not assume the character of an evidence?
My lord, I will say this.
Because then it will become inadmissible and look into it.
Yes, my lord. In fact, your lordship will have to read what you mean by the word existence, what do you mean by the word validity. All different expressions have been used in the Arbitration Act. Very interestingly, existence has been used somewhere, validity has been used somewhere, jurisdiction has been used differently somewhere, arbitrability has been used. I'll show that, my lord. So, my lord, because really a Section 11 court, my lord, in some senses is a court,
ministerial court anymore.
is my lord,
It is a mind applying court.
my lord, the question is, again, my lord, we should not fall into the question of judicial versus administrative. My lord, I would rephrase the question. I would say what is, and that is how the Law Commission says, what is the scope of inquiry of the 11 court? What is his scope, his or her scope? That's the expression, my lord, which is used.
Scope
What
is whether there is an arbitration agreement or not.
My lord, in fact, I will show, my lord, there is an emphasis on the word existence. The legislative history shows that the words used are, my lord, very interesting. Confine, first the word confine, namely, my lord, you are limited to the examination of the existence of an arbitration.
Yes. Now, where do I find that one? Where do I find that arbitration agreement?
My lord, in the document, no difficulty.
In the document.
My lord,
The document is produced as an annexure.
right, my lord, but your lordships are not
Treated as an evidence.
Right, my lord, my lords are not admitting it into evidence in the way that you are required, my lord, under 33 or 35 to do.
Summary proceeding like in read.
Right, my lord.
All the annexures are also evidence.
My lord,
And they are affirmed on oath by the very
let me, my lord, tackle that.
Anyway, you go on.
No,
in your
I understand. My lord, the question really is whether you can even look at that document, because by looking at it, you are admitting it into evidence. I will show, my lord, that there are different phrases which are used and different ways it has been understood. And the legislative history will show to my lords that what you are really required to look at, and that's also in Vidya Rolia, is that yes, you have to satisfy yourself that there is a concluded contract. You may have to satisfy yourself that there is consideration, some formal requirements you will have to satisfy yourself. But in the process of looking at that document, it will not be going to the next stage of admitting it formally into evidence and deciding on, my lord, the or even, my lord, acting upon it in that fashion. I'll show the, my lord, relevant. I'll show the history of it to satisfy your lordship, because, my lord, it all depends on how you read that phrase. Existence could be read widely. Could be, my lord. It could be said that existence of an arbitration agreement may include whether accord and satisfaction was there or not, because an arbitration agreement ceased to exist because there may be subsequent accord and satisfaction, or agreement exists but limitation bars. this could be, my lord, existence could be wider. Not, I'll come to that. My lord, if I could just go back to the Stamp Act, and then I'll immediately, my lord, come back to that. So, my lord, one is what happens after impounding. That's my lord, unexceptional.
By information 6A of section 11.
6A, my lord, has been deleted,
Not notified.
but not notified.
So, we will examine the effect even after deletion.
Yes.
A is a different context.
6,
It leaves no room for discretion to examine, judicial discretion.
my lord, after,
When the application is filed, you have no option but the
my lord, after,
agreement contained the
Your
clause
Lordship.
of arbitration upon with the arbitrator.
right. In fact, my lord, 11.6A deletion and notification will mean that this matter will completely go away from the courts and be relegated to institutions. That was the thinking of the high level committee. But, my lord, as on today, 11.6A continues. The deletion has not been notified.
And if it is notified, then what will be the effect?
One of the change will be that really this jurisdiction of 11 will be taken away from all courts and vested in institutions which are, my lord, as it were, notified, and, my lord, as per the Supreme Court or the High Court will then, my lord, approve such an institution, and that institution, whatever, my lord, institution will be, will actually just make the appointment. That seems to be the trend which is now going, because, my lord, I want to say one very interesting thing which is not here, which is that there are 85 countries in which there is the model law. This Article 11 is there in 85 countries. My lord, there is something called case law on ancestral texts. I am the one of the national correspondents. No other country in the world has any jurisprudence of any worth on Article 11, on Section 11. Yet, I am before a constitution bench, my lord. We were before 7 judges in SBP. Section 11 has been amended multiple times. My lord, why? My lord, I'll answer this question at the end as to why we are suffering from this Section 11 problem. My lord, there is
Judicial overreach.
no, it is not the court's fault. My lord. Every time we think it is judicial overreach. My lord, I'll answer the question now. In every other jurisdiction, there is a Section 16 appeal. There is an Article 16 appeal. In every other jurisdiction, there is a full Article 16 appeal. So all these questions go to the arbitrator. If the arbitrator gets it wrong, the court may or may not intervene in 16. But we have footballed it right to the beginning so that your lordships are bothered with Section 11 applications day in, day out. Long judgments are written, long debates are there, and, my lord, we are before my lord. That was never the intention of Section 11. That was never the intention, and the statute also makes it clear that you are to confine, my lord, the word is confine. Nobody's seen the word confine. Confine to the existence, to the examination of the existence of the agreement. That's all. That's the Lakshman Rekha. Nothing more. In fact, my lord, I quoted Justice Kurian in Duro Felguera, where he puts it in 2 lines, my lord. He puts it so beautifully. If your lordship sees page 2 of the note, after the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. My lord, I've quoted it, my lord, in the second page. Page 4, my lord. Page 4, my lord. I've quoted this passage. Your lordship just sees this passage. After the amendment, all that the courts need to see is whether an agreement, arbitration agreement exists, nothing more, nothing less.